Good afternoon. Keep eating. Feel free to eat. Feel free to go to the buffet line and have more. But we're going to begin the program promptly because I have promised everyone at these programs that we end promptly at 1:30, and we don't want to run over that commitment. I'm Steve Sussman, the Executive Director of the Civil Jury Project at NYU that was started exactly almost three years ago in September of 2015 in this very room. The Civil Jury Project is the only academic center in the country studying the question why jury trials are disappearing. Indeed, all trials in public courtrooms in the civil trials are disappearing. Whether we should be concerned about that, and if so, what we should be doing. We have here today to say a word of welcome, the Dean of the Law School, Trevor Morrison. Just in time. This is a JIT Dean. Dean Morrison.
Thank you, Steve. Literally a word of welcome. Welcome. Thank you all for being here. The Civil Jury Project really is an exciting initiative, and we owe deep thanks to Steve for the inspiration behind it and for all of the sweat equity he's put into it over these 3 years as well. It is an important issue to be studied. The reasons why the phenomenon of the civil jury seem to be imperiled today, and what, if anything, to do about it, how to think about improving the experience of serving on a jury and improving trials in the civil justice system as effective dispute resolution mechanisms. So the law school is really pleased to be hosting the Civil Jury Project here. Thanks to the judges who joined us for today's conversation, and thanks to all of you for being here as well.
So, no one can argue with the fact that the right to trial by jury was probably the most important right that the Founding Fathers put in our founding documents. It's mentioned in the Declaration of Independence, once in the Constitution, and in 3 of the Bill of Rights. The right to jury trial is so much a part of the DNA of the justice system in this country that there's not a courtroom in the country that doesn't have a jury box in it. But the sad fact is that today, most of those jury boxes sit empty most of the time. This is the number of civil and jury and bench trials conducted per authorized federal judgeship for the last 55 years. And you can see the trend. The red line is jury trials, the blue line is bench trials. When I began this project, I had no idea that bench trials were disappearing as fast or faster than jury trials. But they're now down to a average in this country. The average federal judge in this country tries about 2 civil jury cases a year, 1 bench trial, and not a whole lot more criminal trials. But the criminal trials are disappearing for a different reason. If you look at the district in which we are sitting, the Southern District of New York, and because we have a judge here from the Eastern District of New York, you can see that last year, the average federal judge in the Southern District of New York tried 1.9 civil trials, 1.8 bench trials. The comparable numbers in the Eastern District are 4.7 and 1.4. I need to get out to the Eastern District and find out what they are doing that allows them to try more cases than the Southern District. But in any event, even though that sounds extremely low, the Southern District is about average in the country for the number of jury trials, and the Eastern District, in fact, ranks number 6 among the districts in the country for the number of jury trials per judge. one might explain these numbers by saying, well, the number of filings has dropped. And that's true, they have dropped. But if you look at the statistic of the percentage of cases on the docket that get disposed of by jury trial or bench trial, it looks just as terrible. And it's well under 0.5% across the country in the federal courts. The percentages here in the Southern District and the Eastern District, these two lines show them, again, a downward trend. In the state courts of New York, hard to get the statistics from the New York Supreme Court, but this is a pattern that exists, and this pattern exists around the country. There's nothing, I've been around the country, this is like our 26th jury improvement lunch. So wherever I go, I have these charts made and try to get as much information as I can on the state courts where I am. And the result is, you could almost use the same graph everywhere because, and I don't even get any argument. When I began doing the project, I got argument from the judges. Well, we have plenty of trials, and there are a few pockets where that's true. There's a few circumstances. Some senior judges do nothing but try cases. There are some state courts that still have a central docket where a few of the judges are nothing but trial judges. They try one case after another. As soon as the jury goes out to deliberate, they call up to the clerk's office and another case gets sent down. But with those exceptions, the picture is pretty much the same. One of the things we have done at the Civil Jury Project, to give you about a 5-minute overview before we begin our panel discussion, is to engage in empirical research as to, for example, we surveyed non-lawyers to find out, is the public really aware of these trend lines that I've just shown on the screen? 80% of the people in this country who are not lawyers, according to our polling data, believe that the number of trials has gone up in the last decade. Totally wrong. And there are, of course, reasons for that. The popular shows on television, movies, plenty of interest in trials and the justice system. But the fact of the matter is that the general public is not aware that in many federal courthouses, I'm not talking about the Southern District or the Eastern District now, but in the other federal courthouses I have been to, you can shoot a cannon through the hall during the week and you wouldn't hit anyone. Many of the courtrooms are dark. It's not to say that the judges aren't busy, but they're doing something other than serving as trial judges. People say, well, it's the companies are in love with arbitration. So we went and we did an empirical study. We got some law professors and law students at Baylor to go through all the filings of material business-to-business contracts that public companies have to file with their 8Ks with the SEC. And this does not include any consumer contracts, but just business-to-business contracts. And we looked through over 5,000 of these contracts to see how many contain jury waiver clauses or mandatory arbitration clauses. And to our pleasant surprise, 57% did not. So when it comes time to litigate against each other, businesses in this country still haven't given up on the idea that trial by jury makes a lot of sense. They don't have to pay arbitrators $750 an hour. They have rights of appeal. They aren't dealing with arbitrators who tend to split the baby to avoid extreme results. And we have then, by looking at those contracts, called the general counsel to ask them, was this just an accident or did you intentionally prefer a jury trial? And from the general counsel of Exxon to the general counsel of some of the largest companies in this country, they sing the praises of trial by jury, of course, except in consumer cases. We have now completed hosting 5 full-day workshops on how to improve jury trials. Here at the law school, we held 2 last week. We have now had 150 state and federal judges from around the country come to NYU and spend a day of their time. They are very busy, but the judges in this country are interested. I tell the trial lawyers this because you may not appear to everyone that that's the case, but they want to try more cases. They want to figure out how to try more cases, how to make trial more appealing, cheaper, more reliable, and more efficient. We have, as I said, this is our 25th or 26th lunch like this. We are planning them this fall for Boise. I got to go to Boise on Friday for one of these lunches. Palm Beach the following week, Fort Lauderdale, Oakland, Chicago, and Des Moines. It's taken a lot of time. We have a small staff, but we are doing it because people these lawyers want to hear from jurors what their experience is, and from judges about what their experience and their point of view is. We have over 275 state and federal judges across the country who are judicial advisors. We have 65 law professors who have done research in jury studies, and 35 jury consultants who are advisors to the project. We maintain a website for lawyers and judges and academics, and everything, including the videotape of this program, is on this website by tomorrow. And so you can go back and see all the other lunches and every program we've had. And there's a lot of interesting things. But the main website we have come up with is a different website. This is a website called We the People, WeTheJury.com. This is for people who have served on juries or who have received summons. We have found when we did some surfing of the web at the beginning that there were a lot of talk about juries and jury trials in social media, but it was all about how to get out of jury service. And we figured if we could somehow get hold of those people and direct them to this website, we could change attitudes about that. So you will see here there's one portal on the far left, received a jury summons. When people go there, they are shown video testimonials. We have a juror with us today who is, for example, going to help us make one of these testimonials, which will then be there, which basically tells people who go there, don't throw away your summons, you just received a summons. You are about to have the best experience of your life. I would love to do it again. And from all over the country, we have these testimonials. If you click on the button on the right of the screen that you have recently completed jury service, we have had hundreds of people go there and fill out jury feedback forms, which we collect about what they liked, what they didn't like, how the trial could be improved. We identify those jurors. We ask them to make video testimonials, which we put on the left for those who have received a summons. The effort is to try to increase the yield to jury summons, which is horribly low all over the country. If they, by the way, click in the middle, they are said, you shouldn't be here, the judge told you not to be here. Come back when the trial is over. But we get a lot of clicks there, by the way. We can tell we're getting clicks there. We ask the judges who are advisors, the 275 judges who are advisors, and anyone else who will listen to us, to pass out to jurors at the end of the trial this little card that says you can go to this site if you want to talk about your experience. Now, all over the country, judges keep different kinds of questionnaires from jurors. They informally talk to them after a trial's open, but there's no uniform system of getting juror responses, getting the questionnaire responses, and finding out what jurors really think. And then we go to social media. We have an active practice, Jury Matters, hashtag, to try to find people who are trying to get out of jury service and encourage them not to do so. We put at your table, I hope everyone got a copy of it, but if not, we'll talk about it a little later, a one-page chart of the reasons we think we've been able to identify about 17 or 18 reasons the jury trials are disappearing in this country. We figured it made most sense to try to categorize them between those that we can do something about, which are on the right, and those which we probably can't do something about short of changing the composition of the Supreme Court or having an act of Congress passed or some other legislative or rule change. But the 8 reasons on the right side of the chart are things we probably can do something about. Decreasing the expense, making trials happen quicker, improving the reliability of trials, et cetera, et cetera. And so we go to judges, and I will ask the judges on the panel. I've sent this to them in advance so they can tell us, have we left anything out, and have we properly categorized what is here. We are hearing a lot these days about the importance of the independence of the judiciary and how that the rule of law depends on an independent judiciary. In the federal courts, we have federal judges here today. The federal judges have lifetime tenure, and that's supposed to assure their independence. But 98% of the cases in this country are tried in state court, and about 90% of those judges are elected, many where they identify in partisan elections, where they identify as Republicans or Democrats. And the studies done by the Brennan Institute here at NYU have pretty conclusively established that if a judge depends on the electorate to either get his bench or hold on to her bench, that judge is likely to favor the party that he or she perceives might be of most assistance to them in staying on the bench or getting on the bench. That's kind of a frightening statistic, and if it's true, I have no reason to believe that research was bad research, but if it's true, it just underlines the importance for having jurors in this country. That's why our founding fathers wanted them in the first place, to protect the average citizen from the tyranny of judges, whether they were elected by the people or appointed by the king. And so now I would like, one of the problems, we were supposed to have this, this was supposed to be mainly hearing from jurors today, but it's very difficult to get jurors. I think we've had more trouble in New York than elsewhere. Thank God we have one juror here, and I'd like to ask that juror, Mr. Connolly, to come up, and the judges who have agreed to serve on the panel. Judge Lasnik, who many of you may not know because he is from Seattle, Washington. He was from the Western District of Washington. He is a judicial advisor. He helped me put on, now we have had 2 of these lunches in Seattle that Judge Lasnik has been involved in, and he was at our federal judge workshop yesterday. Everyone knows Judge Furman and Judge Daniels, and Judge McMahon and...
It's McMahon, but that's okay.
McMahon.
Mr. Sussman.
Fair enough. And Judge Garaufis from the Eastern District.
That's pretty good. He did okay with the...
Well, I hope it's good because I asked your law clerk, who is our research fellow now, your former law clerk, to tell me how to properly pronounce your name. So let me begin with asking our real juror to tell us about your experience and just kind of what you thought, what you liked and didn't like.
I served on federal trial. Judge Furman presided just a couple of weeks ago. My experience from the time I walked into the jury selection room was very welcoming, very professional. I have to say it was almost like scripted, that every person thanked us every time we walked in a room, including Judge Furman. You know, breakfast was provided when we were deliberating, and I would say there was never an issue with us not feeling important and welcome.
Okay, and what did you dislike about the experience the most?
Present company excluded.
I did have a complaint for Judge Furman after. It was an unusual case. It was a civil case where the bulk of it, the facts of the case had already been decided in a prior trial. And we were there, as I understand it, we were able to question Judge Furman, which was great afterwards, because we had so many questions. But we discovered after the fact that it was a technicality, if I'm correct, that caused the award not to be made at the time most of the facts were determined. So as we discussed it in the jury room, we had a math problem, which was how much to award. And given this long list of assumed facts, and some that we were able to hear during testimony during the trial. So you asked what was the frustration. Number one, we didn't know beforehand why we were there. In other words, we didn't know really why this judgment wasn't made, at the time of the facts were resolved. We found that out kind of after. That was a distraction, but I'm not sure it really changed our decision. But it was a frustration because there was quite a bit of testimony, I guess in fairness, that we got to hear firsthand to make our award decision. So there was a lot of kind of boring testimony that seemed to be very redundant to us. In fact, one of the jurors passed out, sleeping during part of the trial. And he was dismissed.
So I know, the typical juror, I've now met hundreds of jurors at lunches like this. The complaint I hear over and over again is it was just too repetitive. Fair? Was that a comment you had?
I can be more specific.
Did you think the trial lasted longer than it needed to last?
Yes.
All right, typical. So, judges, Judge Furman, how can we stop repetition?
So, number one, just to fill in some of the blanks, it was a retrial on damages only. I had granted a motion for a new trial, but limited to the question of damages. So I think part of what the jurors didn't fully understand at the outset, and we did talk after the verdict, was, why that wasn't resolved in the first trial, which is perfectly understandable, but for reasons that I'm sure many here understand, I didn't feel like I should explain that to the jury at the outset. And B, I think Mr. Connolly in particular maybe felt that insofar as they were being asked to fix a damages award, why did there have to be a lot of testimony concerning the conduct of the defendant? And the reason for that is that they were fixing punitive damages as well as compensatory, and obviously therefore needed to understand the sort of gravity of the conduct in order to make that determination. But I think, and maybe in retrospect, I could have or should have done a better job of explaining that. I don't think, I told the jury that it would last about up to 2 weeks. My practice, and tell Mr. Connolly afterwards, is always to overestimate, because in my experience, jurors are always happy when the trial ends more quickly than you tell them, and always angry when it lasts longer than you tell them. And it ended actually, I think, in only 3 or 4 days. So in that respect, I think it actually went even more quickly than I had expected. I think part of, what I dislike most is cases where there's a lot of testimony by videotape. And I would say about half the witnesses in this trial were presented by videotape deposition. And I think those in particular, I find jurors have the most trouble kind of focusing and paying attention. It's just a little less exciting than a live witness. And makes it harder for them to.
How about it, Mr. Connolly? How about videotape?
There were complaints among the jurors about the video testimony, but I don't think we had as hard a time with watching video as much as the questioning included just, what did they do in high school, and, just we're listening to expert testimony or testimony of the employees, and we just didn't need, half of the videotape. So even the video could have been shortened.
Judge Mayhaw.
So what you do, if you're an activist judge, I'm an activist judge, I'll confess it, during trial management, you just cut that stuff off. You just stop it. We don't need to hear that. Not necessary to know about your children. Let's move on. We've heard that twice. Let's go, let's move, let's work, let's change, let's this, let's that. And in my experience, jurors appreciate a judge who takes the lawyers in hand and says, we're not going to make this any longer than it needs to be. When lawyers tell me at a final pretrial conference that they're going to call 3 or 4 witnesses on a particular topic, I tell them they're not in a civil case, much less leeway in a criminal case. When lawyers give me an exhibit list that's 150 exhibits long, I tell them that we're there, it's 10 o'clock in the morning. I always do all my admission of exhibits prior to picking a jury. So we're there, it's generally a Friday, and we'll remain as late as necessary, even down to 2 and 3 o'clock in the morning, to deal with all of the objections to all of the exhibits. It has never failed that when counsel hear that, they cut the exhibits down to a manageable number. I think that a whole lot of making trials shorter and less redundant has to do with how actively the judge manages the trial.
So how about being one of the innovations being suggested around the country is that judges should set time limits.
Do that too.
Each side gets so many hours, and it's essentially a chess clock where you keep track of the time.
You have so many, yeah, I won't do that for a 2 or 3 day trial, but for a 2 or 3 week trial, you have X number of hours on your feet.
I do it even for a 2 or 3 day trial. I mean, I find that it's helpful in advance. It gets the lawyers hopefully to cut down on their case to the bare minimum and the essentials. Yeah.
Every lawyer I've talked to that's been in a time limit trial loves it. I mean, they hated at first the idea that they have to do it because it's hard work. It is hard to make choices. But once they do it, and I've never been in a time limit trial where I haven't given time back. I mean, we finish before, and you don't play many video depositions, if at all. So how about, now, how about a rule that you can put whatever you want on the exhibit list that you exchange with the other side before you go there? Anything you put on the exhibit list, you got to show to the jury. You can't just put stuff on there to be, quote, in evidence, a bunch of documents. If it's on the list, I'm going to make you use part of your time showing it to the jury. Well, how about that, Judge Daniels? What do you think of that for an idea?
Well, I mean, I've never found it necessary to set time limits or to set strict rules. Obviously, there's always a danger that you're going to impose yourself where you shouldn't impose yourself, and where it's the province of the jury, and the lawyers complain that they don't get to try their cases. I think I have more discussion with the lawyers about what we're going to anticipate, and I've always said to lawyers that, particularly when they ask me about summations and those sort of things, that I don't put a time limit on the summations, because by the time I tell you to sit down, you will have lost the jury long before that. And so I usually want to know what they're going to do, how long they reasonably think it's going to take, whether that makes a lot of sense to me. If it doesn't make a lot of sense to me, I will say it doesn't make a lot of sense to me. I think.
So why should any closing argument last more than an hour?
It should. It should.
So why don't you give us why don't you just tell us, these are the rules you got to play by, counsel?
I mean, it's a matter of style. I mean, I think part of the problem is that we have less lawyers who are trial lawyers and who really have the skills to do it in and out.
We'll come to that.
You know, I think that we're losing that. I think lawyers are not getting the trial experience that they're used to. I think they're not even training themselves to try cases like they used to. When I first tried a case as a lawyer, I went to the National Institute for Trial Advocacy to figure out what I was supposed to be doing. And I think we don't get a lot of that.
Judge Lasnik, do you set time limits?
I do not set time limits. I use shaming more than anything. You know, I start out jury selection on the first day when we take the first break. I say to the jurors, my wife is a kindergarten teacher, and we have incredibly similar jobs. We both deal with unbelievably juvenile behavior, and I look at the lawyers, and I say, and we both get to say when people can go to the bathroom, and you can go to the bathroom now. And I start, you know, getting a rapport with the jurors where they're looking for someone in the courtroom they can trust, right? They can't trust the lawyers because the lawyers are trying to win. But they want to trust the judge. So, and I use humor a lot in the court to relax jurors, but I also use a great deal of sarcasm. And so the first day of trial is often painful because the lawyers are going way too long, the jurors looking frustrated, they're repeating things. And then at some point, you know, I'll say to the jury, when the counsel asks a question for the fourth time, is there anyone on the jury that doesn't know the answer to this question? And they shake their heads, and I say, counsel, do you think that these people are stupid? Or do you think they're deaf? Or, you know, why are you doing this? And the shaming process leads them to get sharper. So I'm a combination of Judge McMahon in the sense I'm very active, but also Judge Daniels in the sense that I try not to set the limits. And I've never needed to because I've never had a case go as long as the lawyers have said. Never. And I've been wearing the black for 29 years, 9 as a state court judge and 20 as a federal judge. But we're talking about the same thing. We just have different styles of how to get there.
So, now you mentioned your wife's a teacher. Have y'all all seen Order in the Classroom?
No.
You will love it. Here it comes. It's very short, and judges, you may have to get,
Yeah,
I don't know if we can
can't see
turn
it
this
from here.
We
around
can't
at all.
see anything.
We can just walk over.
Yeah, can y'all turn it up?
It's okay. We'll
Now, I realize that you were summoned to this class without signing up for it. And you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on other important aspects of the course. Now, I won't be telling you what is important in this course, or what the rules are for the final exam, until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all.
Thank you.
Had seen that.
So, that, by the way, is a video done in 1998. It was at a time in this country that there was a lot of talk about jury reform. And as a result of a video like this, it's made by the International Association of Defense Counsel, probably to show show their corporate clients about why they didn't want jury trials. It's hard to tell with the purpose of it. But as a result of things like this, the ABA, the American College of Trial Lawyers, made these recommendations in 2000, 2005 for changes, time limits, allowing jurors to ask questions. Now, some of them have taken hold. I haven't been anywhere where they don't allow jurors to take notes.
The New York State Supreme Court.
That's a wonderful question. I need to ask you that. When I told the law school I thought it would be great to have a project like this right here close to all the judges on Foley Square, I thought this would be an ideal place. Federal judges here are very interested in trials. The federal judges are interested in jury reform, as indicated by the fact that y'all are here. But in other states, it's exactly the opposite. The state judges are very interested. The state judges are more reform-minded, in fact, doing different things, adopting different rules. So what's going on in New York? Why is New York, is it something in the water here?
No. I actually am kind of uniquely qualified to answer that question because when we had jury reform in New York, I ran it. But that was back in 1993 when I chaired something called the Jury Project for then new Chief Judge Judith Kaye. And we were able to ram through 82 changes to how jury service, back office, front office, and experience for the jurors worked in New York. Our problem is that so many things in New York are dictated by statute, not just custom, but statute. The reason that you can't take notes as a juror in the state of New York is that it's in the New York state law. And judges have gotten comfortable with that over the years. Some of us, I was a state court judge for a while, some of us bucked that. I broke the law. I gave them notebooks. But most judges they've drunk the Kool-Aid. You don't give the jurors notebooks because they might focus on what it is that they thought was important instead of looking at all the evidence. Fancy that. So it's a political thing. But it took an extraordinary woman with an extraordinary amount of charisma to make major changes in the jury system in New York. And that happened, 25 years ago? And, it'll be another 25 years before there's an equally charismatic person who needs to do that again.
So let's talk about a few of the things. The asking questions, giving the jurors, did you have a right to ask questions? In your trial, did you even know about having a right to ask questions?
I don't think so. No.
Judge Furman, do you let them ask questions?
No.
Would you let them ask questions? If I tell you,
If you tell me to?
No, I'm not going to tell you to. No, I'm not going to tell you to, but I'm going to tell you, Judge Lasnik.
Yeah, this is one that Steve and I had a confrontation in Seattle, friendly, that I don't want the jurors to ask questions and why. But at the last conference we did with judges, I was impressed. A judge from Minnesota, Judge Thunheim, has a pre-printed form. The jurors can fill out the question and put it in a box. He can look at it, show it to the lawyers, see if they want to ask it. And, you know, I'm willing to consider that next jury trial as something I will try.
Great. Judge Garaufis.
Well, I'd be concerned if I received one of these requests, you know, how would I deal with it? Would I require that both sides agree to permit the question? Would it be sufficient if one side said yes and the other side said no, and I said yes? Would that be appropriate? It would be a question of experimentation on my part, and then of course there's the issue about how many questions are you going to get. You may have an activist jury and you may have a passive jury, and sometimes when might be a passive jury, I mean, the judge can ask questions if there are matters that should be brought out, and we tell the jurors that. And so I look upon it as I am acting in the place of the jury where there's an important question that needs to be asked and hasn't been asked and needs to be answered, hasn't been answered. And so I'm doing it on behalf of the jury. But I might be willing to experiment in a short trial and see where it goes, but I don't think that I'm facing a 4-week trial or an 8-week trial in an antitrust case, and I'm busy having the jurors ask questions along the way. The idea that I might have to retry this case, you know, looms in my head if I get a message from my colleagues at the next level that I somehow acted inappropriately in allowing certain questions, not allowing other questions. You know, I'd rather have Judge Furman experiment in this case.
So let me just suggest that I think now about 50% of the federal judges in the country are allowing jurors to ask questions. That's my gut reaction going around the country. There's some states, Arizona, Nevada, Colorado, South Dakota, that it's in the rules. They have to be allowed to ask questions.
Yeah, well, Arizona was the cornerstone of
It
jury
was the
reform in the
epicenter.
Arizona State Courts. It was the epicenter of everything.
So, but everyone, the lawyers who are in trials, I've been in trials, it's done in Texas now, routinely, and frankly, every time we love it, the lawyers love it. You avoid repetition because you know what the juries are thinking a little, okay? You know where they are confused. We're sitting there with a blank slate. We don't know whether we need to repeat ourselves 5 times to get through or not. The questions give us a sign where there is confusion, where we need to ask another question. And so every case I've never had a lawyer who doesn't like it. So, and let me ask you another question then, which is, so I'm going to be able to convince lawyers probably quicker than I can convince federal judges that this is a good practice. So if one of these lawyers here and I are on the opposite side of the case and come in to see you, Judge Furman, and say, Judge, we would like to have the jury have the ability to ask questions, would you agree to do that?
I would be.
Would you consider it seriously?
I would consider it, for sure. I would say in theory, I'm not opposed to this practice. It's more I have practical concerns. Number one, how to implement it. How does it work? Do you, do you get the questions from the jurors? Do the jurors have to agree together that they want to ask a question, or is it up to any individual juror, in which case it may or may not reflect a widespread view on the jury? Do you review the questions with the lawyers? What happens, as Judge Garaufis said, if the lawyers don't agree with respect to a question? Do you get to make that decision? So there's sort of practical things that I think need to be thought through. Second is time. I was talking to a lawyer at the table before the panel started who said a colleague of mine does permit this, and at the end of each witness, they would get questions from the jurors. They'd retreat to the robing room, have a 15-minute conference, and then go back to the courtroom. To me, adding 15 minutes at the end of every witness where the jury has to sit in the box have no idea how long you're going to be. I mean, my view is once the jury's in the box, their time is the most valuable thing in the courtroom, and I'm going to do everything in my power to make sure that trial ends as quickly as possible, within reason, and allowing lawyers to try their own cases. And I would just have concerns about institutionalizing a practice that just causes repetitive delays and things outside of the hearing of the jurors. So all of which is to say, I would be open to it, I would think about it. And the third reason I would say is just path dependency. It's not a very good reason, but candidly, I've never done it. I would think I would need to think through all these things, and that takes time. And when you have 200 to 500 cases on your docket, depending on how you count, it's just so much time you can devote to any one thing, and it's sort of hard to think through these things. So
This is where I want to tell the famous federal judge joke. How many federal judges does it take to change a light bulb? And there are two answers. One is just one. He holds up the light bulb and the entire world revolves around him. And the other is change, change. Who said anything about change? And, I totally feel the same way Judge Furman did, and that's why I've never done it. My colleagues who do it say, it never happens like that. It doesn't happen after every witness. It doesn't slow things down. It actually makes things work better. And at some point, I'm going to have to say, change, okay, I'll try it. And it's getting close.
So it's always been kind of curious to me too. Maybe someone has an explanation. State court judges who are subject to election seem to be more willing to experiment with things, even though it may upset lawyers who appear before them, than federal judges, who you're the law. All these innovations, I am confident every innovation we are preaching for jury trials, you have the power, the federal judges have the power to do it, and you're there for life. So why is it that,
Well, we are
what's the
such a
explanation?
conservative organization, and by that I mean, you look at the leadership of the federal judiciary, and it's older people and set in their ways people who get to be chairs of committees. Nick finally got old enough to be a chair of a committee.
I had to become 70.
Yes, yeah, no, seriously. And
Thank you.
you go to the US Supreme Court and, there's people who, this is the way we've always done it. You try to get change in the judicial conference. Well, who sits on the judicial conference, which is the governing body of the federal courts? It's the chief circuit judges from each of the circuits. Well, how do you get to be chief circuit judge? The most senior of the active circuit judges who has never been chief before, which tends to put people on as chief circuit
Well,
judge.
I'm on the judicial conference, and I'm not the chief circuit judge.
No, district judges are elected in different ways. I was on the judicial conference, but changing it
she's
as
the chief district judge.
yeah, changing it as a member of the judicial conference just doesn't happen. It's the executive committee where all the power is, and those people are hand-selected by the chief justice. So we have a tendency to say, we don't do change well, and we're sort of guardians of a history of the federal judge being an organization that doesn't change. Whereas in state court, things move quickly.
I think also, someone pointed this out to me at one of our workshops last week, that state judges, because every juror is a voter, is very much more concerned about making life pleasant and happy for jurors than federal judges tend to be. I don't know whether there's any truth to that.
There
or
is
not.
we
I
are
don't buy that.
both old New York State
There's no
judges.
truth to that?
There is zero truth to that. And if you did a survey of people who have served on both state and federal juries in New York City, you would find 100% of them preferred their federal experience.
That's certainly my experience as well. Let me throw out one hypothesis, and I don't know if this is right with respect to all courts, but certainly I think some of it may depend on the docket system, right? So we carry dockets of, again, depending on how you count, anywhere from, or depending on the judge, anywhere from 200 to 600 cases. At any given time, I have 20 to 40 serious substantive motions that are, sitting on my desk that I need to make my way through. My overriding concern is simply time management and getting cases across the finish line. I think in a lot of state court systems, they don't, if there's a trial part, a judge receives a case for trial and they're not carrying a docket of 300 cases that they need to worry about. There may be another trial coming down the pike, but it's not necessarily their concern until it lands on their lap. And given that, there may just be differences in the pressures.
If you have, yeah,
I would point out, the committee I'm chairing is on inter-circuit assignments, where judges in one circuit are willing to serve in other circuits. Most of the judges so far, in my experience in the year plus that I've been on this committee, want to be on, sit by designation on a circuit court in another circuit, usually in Pasadena. But
Honolulu.
are you going? Anyway, but the fact of the matter is that we have a list of maybe over 100 trial judges in the federal system who are willing to try cases in other districts and circuits. And there really isn't a great large call for judges to try jury trials in other circuits. And I think that goes to the issue of the fact that there isn't a demand for jury trials in the federal system for whatever reason. So when you go back and you look, for instance, I prefer to go try a case in New Mexico or Montana, and we have judges who do that, but there aren't that many opportunities to do it because there just aren't that many trials.
so one of the explanations for that at the top of the list of my two-chart list is that jury trials are too expensive. Do you think jury trials are more expensive than bench trials?
No.
I agree.
No, I agree with that too.
Do you
No.
think,
Same discovery, same motions, same everything, and then in the bench trial, you have to do all this pretrial stuff. You have to give the judge findings of fact and conclusions of law and this and that before the trial, and you have to do a brief at the end of the trial. Much cheaper to try a case to a jury.
do you think arbitration, discovery is any cheaper in arbitration
Absolutely not.
than trials?
Absolutely not.
Most of the arbitrators are former judges anyway, so they're kind of taking their ways of doing business to the conference room, from the courtroom into the conference room. Let me ask you this. Is there anyone here, I've heard this said, judges, someone said they heard judges say, if I have to try a case, I'm a failure. Now, do you think that, Judge Furman?
No.
Because you're concerned about time and time management.
No, I mean, I think that it is not a great thing for the system writ large that the number of trials has declined as precipitously as your graphs tend to show. I think the complication is that in any given case, it's often more rational for the parties and the judge to resolve the case without a trial, which is to say that, given the risks involved, given the expense involved, given, frankly, that there's often a sort of, within a band, a reasonable outcome that can be negotiated, that it makes much more sense to resolve it in some other fashion. So, and in my experience, and there are a couple lawyers here who have cases before me or have even tried cases before me, and so I exclude them, but I would say about half of the cases that I've had that have gone to trial, I think the lawyers just aren't good enough to get it settled. They either can't persuade and explain to their clients the rationality of a settlement, or they can't simply negotiate a settlement, and it's almost the trial is, a last resort.
So, but in the 70s or the late 60s, when those numbers were high, the numbers of trials per judge and the numbers of percentage of cases, see, I began trying cases in the late 60s, so I've been doing it for a long time. I thought the risks were even higher than they are today. Today, there are caps on damages. There are limits on punitive damages. I mean, has it gotten riskier, really, or more dangerous to try a case? I would have thought it got safer to go to trial. They're worse. They're not as bad things can happen to you today.
Well, that's maybe true in Texas, Mr. Sussman. That we don't have those things here.
You don't have that in New York?
We don't have caps on damages in New York. We don't have caps on punitive damages.
No, you just have interlocutory appeal, so anyone to file a
In
case.
state court, we
State
have,
court.
in
Not
state
federal.
court, we do indeed have interlocutory appeals that make cases go on and on and on and on.
New York happens to be the only place where I would rather file a good plaintiff's case in federal court than in state court, which is saying something, of all the states. Let me ask the question about jury instructions. I mean, the students up there were aghast at a lot of things, but one of the things they were particularly aghast at was that they'd wait till the final exam to be told what the questions are going to be and to receive any guidance on instructions, basically. So one of the recommendations, and all these recommendations I'm talking about now have been on the books for 20 years. I mean, it's not like I'm inventing them. Is that judges should give substantive instructions at the beginning of the case rather than at the end of the case. And by substantive, I mean more than just who has the burden of proof and how you judge credibility.
You don't mean rather than, you mean in addition to.
Well,
Because we have to do it at the end. I think it's a great idea to do it at the beginning.
Right.
But we're kind of stuck with the problem that in federal courts, we must also do them at the end. So reading them twice
how did
is
Tom Martin? So one of the things that's fascinating about this project, what I found going around is that judges, even in the same courthouse, do not know what's going on in the chambers next to them. You don't sit and watch what another judge is doing. And so one of the workshops, Tom Martin, who was the chief judge of the District of Kansas, says his preliminary instructions are his final instructions. He does not give them again. I mean, he gives them at the beginning of the case, and that's it. And he may cross, you remember he said that, he told us that. How does he get away with that?
He's in Kansas.
So, Mr. Connolly, in your case, would you have wanted at the beginning of the case more instruction?
I think Judge Furman did an excellent job of preparing us to make the decision. In the beginning, we were aware of what our job was, and it was repeated at the end as well. But all along, we had, great respect for the judge and the process. So,
Do any of you set cases for trial early in the discovery process? Or do you wait till the case gets trial ready?
We set them early in the case management schedule right at the beginning.
At the beginning of discovery?
Yeah. And we're about 18 months out.
How about Southern District, Eastern District? What's done in?
different judges do different things. Some set them early. I don't. I wait until discovery's done. But I have a very tight, 9-month timeline on discovery, rocket docket discovery. So
That is
discovery
your
can't
rule.
go on and on and on and on and on and on and on. Yeah.
Okay.
And then when I give them a trial date, it's about 4 weeks in the future. That's it.
Have any of you judges, it occurs to me that one of the most expensive parts of a jury trial is the need to prepare a long pretrial order in which you do a lot of unnecessary work, like designate your deposition excerpts way in advance. Always 99% of the stuff that's designated doesn't get shown or read to the jury, but it is a huge waste. It's a make-work project for associates on a trial team to go read depositions and designate them. So y'all require that, or would you dispense with
Yeah, and I
that?
don't expect the associates to be doing it. I expect the fellow who's going to try the case or the woman who's going to try the case to look at what the associates come up with and to decide what's going in, because if it's on there, it's going to get shown.
Well,
So I think final pretrial order is a great way to force a lawyer to prepare a case. And if you don't want to prepare your case for trial, that's the moment you should settle.
do you require the lead lawyers on both sides to talk to each other? I mean, we have all this meeting and conferring, and I just was on one for about 30 minutes before I came in here with one of the lawyers in Seattle in my office in Seattle, and these things go on forever and ever, and there are just 20 lawyers on the phone. I think I could have resolved the problem had I talked privately to the lawyer on the other side, but everyone had their legions on the phone. Does anyone have the rule that a meet and confer must be between the lead lawyers? That's okay,
Well, you can do it however you want. If you want to waste your client's money by bringing 10 people in a room, go right ahead. It won't be your client for very long.
the ABA and the American College suggested 20 years ago that lawyers be allowed to participate in voir dire, jury selections, asking questions. In your case, did Judge Furman do all the voir dire? Or do you allow?
So, yes.
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 I do not let lawyers ask questions, and I am very resistant to the idea of letting lawyers ask questions.
As well
Yeah.
you should be.
I thought it would be fun to try a case before Judge Furman, but I'm getting second thoughts about it.
Well, you know, Judge Daniels and I have a lot of experience with lawyers doing voir dire, because by law, in New York State, can't be changed without the legislature doing it. Lawyers get to do some voir dire in every case. And in fact, in civil cases, they do it all unsupervised. It can go on for days. And I don't know how you feel, but having been through that experience and having seen how bad lawyers had at voir dire, ain't no lawyer ever going to ask a question on voir dire in my courtroom.
I experimented with it. And after my brother was voir dired in a case in the state court, and they asked him about, his grades when he was in high school, and he refused to answer the questions and got hauled before a judge for the fact, because he wouldn't answer the lawyer's questions. And he told the judge, it has nothing to do with the case. We've been questioned for 3.5 days, and I would really like to try this case, but I'm getting old. And so I said, well, maybe I should allow the lawyers in a particular case that I had. It was a very sensitive case. Maybe it was the wrong case to do it in. But the lawyers asked if they could ask some questions. So I had asked some questions. And then one of the lawyers, defense lawyers, said, I'd like to ask some questions. And I said, go ahead. And the first question was such a incredibly leading question. I called them up to the sidebar and I said, could you possibly put that in a more neutral way? And the lawyer said, oh yes, I can do that. So we went back and the lawyer asked it differently, but it was totally unacceptable. And so these jurors were being questioned one at a time, individually in the box. And there was nobody else there, no other potential jurors there. And when that question was asked and answered, I held I excused the juror, and I said, our experiment has failed, and we're going back to having me ask all the questions, which I did for a good long time. And it's not easy to ask all the questions. It's better if someone else, if they spell you, and somebody else asks the questions, the lawyers. But I was
I
not.
want Judge Daniels to answer
I
this.
was not.
Judge Daniels.
Well, wait a second. I lost any willingness to engage in that process as a result of that.
Well, my attitude is I do what I think I'm good at. And in most cases, if you want, a lot of lawyers say they want the judge to experiment. They just don't want the judge to experiment on their case, okay? They want you to do what you think you're good at and get it done. I try to figure out one of three things. Is it going to save any time? Is it going to make the experience any better for the juror? Or is it going to affect the result? Is it going to make it more likely the result is going to be the right result? And I realize that, there are not any right and wrong ways of doing things. Even in law, there's no right and wrong answers. There are
Right.
answers that work and there are answers that don't. I try to make the stuff that work that I do. I find lawyers are very inefficient in most cases about it. I think, I remember one experience after the lawyer finished voir diring the juror, the juror said, You're right, I agree, I can't be fair. I cannot stand you. That's all the juror said. The juror was perfectly fine before
Well,
that. But by
well,
the time we got through voir
That's, of course, I might suggest that's a pretty good thing for that lawyer to find out.
well, but it's not, but
But-
you know what, the lawyer would, it's not something that he just found out, it's
So-
something he created. That
I
he could
have-
have won the case if he hadn't gone through the voir dire experience. Very
But-
good lawyer, knew how to cross-examine, knew how to do direct examination, knew how to argue. But the question is it really going to make the result better?
Well, I think
Or
it's
is
a
it going to
bigger-
make the experience?
It's bigger than that, Judge Daniels, because there's social science out there that shows that jurors are more likely to answer honestly questions of the lawyers than questions from the judge, because they see the judge as an authority figure and they want to please the
Sure.
judge. So they say what they think the judge wants to hear.
That
And
you
I-
could fairly consider it,
Yeah,
follow my
and
instructions.
especially in the area of trying to tease out implicit bias. There's been some social science that says jurors are more likely to admit to biases or to acknowledge certain stereotypes with questioning from lawyers than they are from judges. So I've, I mean, there's a lot of bad voir dire out there by lawyers, true, but I let them do it under, strict time limits. And I think it's important to not just say we do it better, which I agree we do, but you want the client to feel that the jury was selected in a fair and impartial manner, and you want to make sure you're getting all the issues out from the jurors, which won't necessarily happen if it's just judge
I mean,
questions.
that's fine, but in 90% or more of the cases, it doesn't make a difference.
So-
If you do it well. The question is whether you do it well.
Every judge thinks they do it well, though.
No, but every lawyer thinks he does it well too, so
That's
I'm
right.
not judging who's better at it.
No.
I'm just saying that it doesn't necessarily
Let me-
follow
I mean,
that it's
my-
adding something
Yeah,
to the
what-
experience.
My
What it
problem.
may add is what every trial lawyer says, that litigants accept a verdict of a jury better than they accept a judgment of a judge in a bench trial or a decision of arbitrators. They somehow, if they lose a jury trial, they blame their lawyer for not submitting the right case. If they lose a bench trial, the judge was corrupt or stupid or some other excuse. So there is an advantage, I think, to the public and to our system of justice to have decisions that are accepted by the litigants. Okay, I lost. Let me, on the subject of voir dire, so to just cover it, a lot of federal judges, now my experience is that about 50% of the federal judges are like you, allowing lawyers to have 30 minutes aside voir dire. And some of them say, you better not make any argument, because I'll stop you, and don't give these long leading questions. You can ask questions to people for 30 minutes each, which is not a long time in a week-long trial. But judges have told me around the country, I tell lawyers, I'm going to do this, and they say, no, Judge, you do it. I don't want to do it. And the comment being, the judges think, the lawyers don't know how to do it. They have not been trained. And you can go anywhere in the country. I challenge you to find a CLE program, a PLI or anywhere else, where it teaches young lawyers how to voir dire. It's not taught. It's not offered. So no wonder we have lawyers that say are not unhappy about the judges doing it. But that brings me to the issue of training of the advocate, because I do think that we will lose jury trials if we don't continue to train young lawyers to conduct them. And of course, with fewer and fewer jury trials, 2 per judge in the country, there are fewer opportunities to conduct that training. So let's talk about what we might do together, the bench and the bar, to help. One thing that has been suggested that's become very popular around the country is what's called the young lawyer rule. And I'm sure I know you've heard about it, the ones who have read our workshop, which is a rule that basically says if you are a young lawyer or a lawyer who's not experienced, notify the judge that you will be conducting the oral argument on a motion. We will give you a hearing. Otherwise, I'm likely to do it on the papers. And this apparently is having the effect among the judges who announce that kind of rule. And there are dozens of versions and flavors of it, but of getting younger lawyers on their feet to make substantive arguments before the judge. So have any of you thought about experimenting with that?
I mean, we've done that. I mean, Judge Weinstein encouraged that, and a lot of the other judges have followed that rule. But you got to be careful. Look, you can't, I'm not going to tell the lawyers how they're supposed to please their client and what they're supposed to do for their client. You know, maybe this argument requires the partner to argue it. I don't know. I don't know who's going to do an effective job of it. I would encourage them to get the younger lawyers to have that experience, but
it enables us, it gives us cover with our clients in a way. I can go.
Yeah, it doesn't, you know, and maybe it's because of the side of the case that you ordinarily find yourself on.
Right.
You're plaintiff's lawyer. The defense bar is, out of which I come, is pretty adamant that they're upset with this rule, and not because they don't like training their young lawyers. I mean, I was in a big firm in another era, and a long time ago in a galaxy far away, but I got a lot of experience in court because in those days it was economically feasible for partners to send me down, especially on cases where they hated the client or they hated the opponent or they hated the judge, and they sent me down on all three. And I got to do a lot of stuff on my feet. Today, what I hear from my former partners and others is we would really like to have more opportunities for our young lawyers, but at the rates we're charging, with whatever it is that we have on the table, the client is adamant. You're the lawyer I hired, you're the lawyer who's going to stand on his feet, and you're the lawyer who's going to argue to that judge. No young lawyer is going to lose my point for me.
I know.
It's not training anymore.
But the rule just simply says if it's going to be a young lawyer, I'm going to provide an opportunity for oral argument because it's part of the training. It doesn't mean I'm not going to consider fairly other motions or something. I just may not have. I don't need to hear from Steve Sussman.
I don't have oral argument on 98% of my motions, but in the 2% where I need it or want it or will profit from it, if the client doesn't want the young lawyer to argue, no matter how badly I'd like to hear from her, if the client doesn't want it to happen, it's not my place to say it must happen.
And see, I'm just the opposite. Most of the cases I probably do have oral argument, and I'll let the lawyers be heard. And if they want to bring in the clients to sit in the front row and listen to the arguments, then that's fine.
How we can give trial training to young lawyers? What's the answer, Judge Furman?
So I do have that kind of rule, or I don't know if it's a rule, but my rules say that I don't ordinarily hold oral argument on motions, but if a party indicates that a younger lawyer would argue it, that would be a factor in my consideration of whether to hold oral argument, and so in that regard, I do have such a rule. I think, I mean, some of it, I do think that the number of lawyers who can ably try a case is, I mean, I don't have a comparative sense because back in the 60s that you invoked, I did not exist, but I do think that number is dwindling is my sense from talking to folks. I think more training and you know, I think partners like you encouraging associates to take the lead on things. I mean, candidly, in my experience, clients often make ill-advised choices in saying that that the partners should handle something because it's the associate who has done the research and actually, you know, knows the witness, knows the case law, knows the facts, and is really the one who's feeding the partner the Post-it notes to say this is the question you should ask. Let the associate ask the question.
Well, you know,
they're going to do a better job.
Some things even I need So I'm a fairly experienced trial lawyer. But I, for a long time, kind of lived by the idea that in Texas, trial lawyers were sole gunslingers. You walked into court with your boots, the jury noticed you, you had a legal pad, not a bunch of associates sitting around, because you didn't want people to think you had an army. Although you did have an army, they were back in the hotel. They weren't in court. I have come to realize over time by talking to jurors and judges like you that that's stupid. Jurors actually like to see a bunch of different lawyers asking questions. They do not get upset if there are 4 or 5 lawyers at counsel table. I mean, some of the rules, there's a rule in the Eastern District, in the federal court, Eastern District of Pennsylvania, that says lawyers cannot split final argument, okay? Why isn't that a stupid rule? I mean, frankly, I think it's a totally stupid rule. If you allow a lawyer an hour, as long as the time's limited, they want to split it any way they want. But we need help from you to tell us, you know, it'd really be nice if you had 4 lawyers out there and you gave me each equal jobs at trial. The jury would appreciate it, I would appreciate it, my law clerks would appreciate it. You're shaking your head?
No, I just had such a trial. It's a criminal trial, where there is no vanishing criminal jury trial. And it was a criminal trial. It was a big, high-stakes trial. And there were teams of at least 5 lawyers for the 2 defendants. And I heard from every single lawyer in that courtroom and took note of it. It was great. It was great. I don't think any of us is opposed to it. It's just that we're aware, or we're being made aware, perhaps they're all lying to us, these members of the bar, saying that they really can't give the opportunities when they're really hoarding them for themselves. I don't know. But we are hearing that there are constraints on having judges announce. Yeah, I asked a young woman lawyer, to stand up and argue a point, and she went like this. And looked at the older male partner like a frightened deer, and he said, I'll be doing this.
Thank you very much, judges, and Mr. Connolly. Thank you for coming. We're out of time now, and I hope it's been fun for you as it's been fun for me. I love each of these because I learned different things. Thank you very much for this.